The views and opinions expressed on Reasonably Speaking are those of the speakers and do not necessarily reflect the policy or position of the American Law Institute or the speakers' organizations. The content presented in this broadcast is for informational purposes only and should not be considered legal advice. Please be advised that episodes of Reasonably Speaking explore complex and often sensitive legal topics and may contain mature content.
Welcome to Reasonably Speaking. I'm thrilled to welcome Elizabeth Scott and Marsha Levick, experts in the area of juvenile justice. Marsha co-founded the Juvenile Law Center in 1975. Juvenile Law Center is the first nonprofit public interest law firm for children in the country. Throughout her legal career, she has been an advocate for children's and women's rights and is a nationally recognized expert in juvenile law. She has successfully litigated challenges to unlawful and harmful laws and has authored or co-authored numerous appellate and amicus briefs in state and federal appeals court, including before the U.S. Supreme Court. Elizabeth Scott is the Harold R. Medina Professor of Law and Vice Dean for Curriculum at Columbia Law School. She teaches family law, property, criminal law, and children in the law. She has written extensively on child custody, adolescent decision-making, and juvenile delinquency. Her research is interdisciplinary, applying behavioral economics, social science research, and developmental theory to family and juvenile law and policy issues.
Welcome, Marsha, Elizabeth. Thank you so much for joining us today.
Thank you.
It's our pleasure.
Elizabeth, if I could start with you, will you begin by providing our listeners some background and the history of children in the justice system in the United States?
Well, that is a big topic. The juvenile justice system began well over a century ago at the turn of the 20th century, and the model of juvenile justice that was developed by progressive reformers was very much based on a notion of juveniles as children who needed guidance to reform. It was known as a rehabilitative model, so that the purpose of intervening when kids got in trouble was to set them on the right path again. That model came under attack in the late 1980s and 1990s when there was a movement pretty much to dismantle the rehabilitative model of juvenile justice. It was triggered to some extent by an increase in juvenile crime, particularly violent crime, and in a view that the juvenile system coddled young offenders and was insufficiently concerned with public safety. And so I think what captures that period of justice policy in the 80s and 90s was the mantra, adult time for adult crime. So the idea, which had been at the heart of the traditional juvenile court and juvenile justice system, that juveniles are very different from adult offenders and that the system should respond to them as children, was sort of swept aside. And the view that kids should pay for their crimes, they should be held accountable, that there's not really a good reason for treating them differently than adults, began to take hold. And as a consequence of that change in public attitudes, legislatures, courts to some extent across the country, changed the law so that it was much easier for juveniles to be treated as adults, to be prosecuted in criminal court, to be subject to adult criminal sentences. And even in the juvenile court, there was a view that the system wasn't tough enough, needed to get tougher. And so the use of incarceration increased, where probation and community sentences had been much more common. Earlier, it became more common to send kids off to institutional facilities during that period.
So, Marsha, you are dealing with children daily. Can you tell me, do you agree? And where do you think it's gone lately with children in the justice system?
I think that really, in a way, the most interesting trend that I see today that is coming directly out of what happened certainly during the 90s, the late 80s, with respect to how we began to view children, is that we've actually come full circle. We started over 100 years ago with this intuitive understanding that kids were different, and a realization that we should not treat them the same way that we treated adults who were involved in the justice system. And as we came out the other end of the 90s and the moral panic that was created as a consequence of this view of this looming generation of super predators, we have come back to a scientifically based understanding, as opposed to just our own intuitive understanding, that there is a scientific reason for why kids are different, and most importantly, why we should consider them to be less culpable and less blameworthy for their conduct. And that has opened the door over the last 15 years approximately to a return to first principles, I would suggest, a return to a focus on rehabilitation and treatment, because we are viewing kids as children and adolescents who can change, who are not fixed, whose personalities, as they go through this natural stage of human development, will change over time as they mature and grow into adulthood. And as someone who has a long view, having been in the field for a long time, Buffy and I share that, we've watched this transformation, how we came into the system, came into this work when we were essentially embracing the therapeutic model. We abandoned it during the 90s because of this anxiety about a surge in violent crime, and we have come back to it with this scientific vocabulary to back up those responses.
And I think that is so important in the sort of most recent wave of reforms, because to some extent the traditional rehabilitative model was based on a view that offenders are children, but there wasn't really substantial support for that claim or that presumption. And today, I think we have, as Marsha said, a more scientific view. And to some extent, I'd say we no longer think that young offenders are children, but we think they're adolescents. And that's very important in thinking about and in responding to their criminal conduct. And the more we know about adolescence and the way that it can affect teenagers and contribute to their tendency to get involved in criminal activity, the more it makes sense, not just for their welfare, but for society's welfare, to respond to their crimes in a way that sort of maximizes the likelihood that they're going to become non-criminal adults. That's sort of a sounder basis, I think, for a rehabilitative model than the original sort of kind of optimistic and rosy view of juvenile offenders in the early 20th century.
So when we're talking about juveniles or children or adolescents, what qualifies? What age? What age are we talking about?
Well, the jurisdictional age is set by statute. That it's sort of when an individual who commits a crime will be dealt with in the juvenile system or in the adult system. And in most states today, that age is 18. But a youth who commits a crime or who's charged with a crime can be charged in some situations at a much younger age as an adult. And the research on brain development suggests that maturation continues into the 20s. Now, we don't treat 20-year-olds as juveniles in a separate system, but this research suggests that, like younger offenders, they also are in a sort of transitional stage and are more amenable to treatment, perhaps, than older offenders.
And I would add that I think the definition of who's eligible for juvenile court jurisdiction is not only subject to a rethink at the upper age, it's also something that we're now re-examining in terms of the floor for juvenile court jurisdiction. And most likely age that most states probably choose for eligibility to be charged as a juvenile delinquent is probably around age 10. There are a number of states around the country that have no lower age jurisdiction at all, so a child of any age could theoretically be brought into the juvenile justice system. And yet, this past weekend, the governor of California signed into law a new provision of California's Juvenile Court Act, which sets the floor for juvenile court jurisdiction at 12. It has raised the floor. And it's not groundbreaking in the sense that it's the only state in the country, but it is reflective of this really increasing willingness to re-examine everything about how we're thinking about kids in the justice system and even young adults. As Elizabeth said, we're thinking about young adults as well, and whether or not we can push the age up for the opportunity to benefit from the interventions of the juvenile justice system, but also re-examining that floor. And I think that it makes it fluid. It makes it more challenging for policymakers who are trying to keep up with the research and with the latest thinking and knowledge that is coming to the forefront. But it's also an exciting time because what we're really doing here is really trying to match policy to science and research. And that seems like a good foundation for how to think about this work going forward.
And this is a period, as Marsha suggests, in which policymakers are remarkably open to learning from scientific research on adolescent development and applying it to policy. I don't think we've ever seen that before in justice policy. And there seems to be even for many conservatives who tend to be a more sort of tough on crime, there is a recognition that juveniles are different from adults and that it is less costly for society, as well as more likely to reduce recidivism, to recognize those differences. And so what we've seen in the last decade or so is a sort of convergence of left and right, not everyone, but to a remarkable extent, in forming a consensus that we really should treat juvenile offenders, for the most part, differently from the way that we treat adults.
So tell me a little bit more about treating them differently. What do they require? What should we be doing to protect them, perhaps, once they enter the justice system?
I think there are a number of ways in which we aim to treat them differently. Again, in a sense, thinking about the original juvenile court, one of the key objectives of that court was to really remove from kids and from children the consequences of a criminal conviction. So the stain of having that felony conviction and the degree to which that would inhibit future participation in any number of civic and community and employment-related activities. The desire to, yet again, ensure some safety from those consequences, I think, is very pervasive in how we are thinking about the juvenile justice system today. And so increasing opportunities for expungement of records, looking at the consequences of a delinquency adjudication with respect to things like eligibility for housing, public housing, for example, removing the existence of a delinquency adjudication or possibly even a delinquency arrest from the common application for college enrollment. That's a development that just happened within the last few months. Very significant in terms of ensuring that if we truly believe in the idea of second chances for this population of young people, whom we believe are less blameworthy for the conduct that they engage in and who we believe will change, then having these kinds of protections built into a system that spares them those very negative consequences, I think, is key.
There's also been a shift away from institutional placements and toward community-based programs. And so in some states like New York, and most kids are dealt with in the communities to the extent possible, staying in their homes. And what the research has suggested is, and it supported pretty strongly, is that those community-based programs are just as effective at reducing recidivism, more effective than institutional placements, which were associated with very high recidivism rates.
Yes, to Elizabeth's last point, the reduction in incarceration of children has been quite dramatic. And over the last 10 years, that population has decreased by about 50%. So you had closure of institutions in New York. You've had closure of institutions in jurisdictions around the country to varying degrees. And you've also had this willingness on the part of whether it's judges who make the placement decisions or executive agencies that make placement decisions to examine community-based alternatives, to utilize them more readily because of this recognition and really scientific research supporting this view that it's not only that they are as effective as an institutional placement might be, there's no evidence that institutional placements actually reduce crime. Keeping kids closer to home is just good practice.
I think this is a good example of the point that programs that are responsive to developmental knowledge that are better for kids are also better for society, since the concern that the critics in the 80s and 90s raised was that the system was not sufficiently focused on public safety. And what the recent trend has been able to do is to move toward a response that's much better for young offenders themselves, but also better for society in the sense that these programs, these community-based programs, reduce reoffending rates, which is what a lot of people who may not care that much about young offenders care about.
And I think part and parcel of this conversation is that the fear of the 90s that we were confronting a significant surge in violent crime didn't come to pass. It's not just that it didn't happen. It's that beginning really in 1994, violent crime among both young people and adults has been declining. It's either declined steadily or it has flattened out. It has not gone up in any significant way at all. Perhaps there are blips here and there, but overall, this is a downward curve that we've witnessed. And the importance of that, we have to recognize, I think, as much as we want to think that all good things happen because of a progressive mindset. The fact of the matter is that low crime provides an environment in which everybody can come to the table and have a conversation that is more open to being innovative and thinking about alternatives because they're not worried about the criminal walking up behind them. There's so much less crime. I think we're at crime levels now that have not been this low since the 1960s, that it just provides a cushion for policymakers. Yes, takes the pressure off.
Incarceration currently is down about 50% than what we saw at its peak. Would you say that this is true for juveniles across the board?
No, unfortunately. So we know historically that both the juvenile and the adult criminal justice systems have been historically disproportionate in terms of their treatment of youth and adults of color. And the disparities among youth of color and their white peers have been persistent and pervasive in the juvenile justice system. The reductions that we've seen, the shrinking of the footprint of the juvenile justice system, while it is indeed something that we will applaud, the reality is that the system not only is as disproportionate as it ever was, it is actually worse. And over the course of the last 15 years or so, the racial disparities have actually increased about 15%. So we are still looking at a system that is largely populated by young people who are Black and brown. And it is perplexing because even as we can talk today about the many ways in which we have become not just more progressive, but more humane, more effective, kinder in how we think about kids and recognizing their potential for reform and giving them those second chances, we often leave kids of color behind. And I think that it's really important as we're having these conversations today that we also look carefully at our history. And I think that individuals like Brian Stevenson in his work and writings, Ava DuVernay, who did the documentary 13th, I think that they have really perfectly demonstrated the straight line between slavery and racism and the justice system in this country. It is a legacy that we live with. And I think as much as we can point to many good things that are happening in the justice system today for kids, unless and until we tackle the racial disparities, we will not be able to feel good about the work that we're doing.
I think that it is particularly frustrating that we not only haven't made progress, but the situation seems worse now than it was a generation ago, because it's not that people are unaware of this problem, and it's not that there isn't a conversation about race. There is a conversation about race. There are many, many people who are very concerned about racial disparities in both the adult and juvenile systems. Frustrating that we not only haven't made progress, but the situation seems worse now than it was a generation ago, because it's not that people are unaware of this problem, and it's not that there isn't a conversation about race. There is a conversation about race. There are many, many people who are very concerned about racial disparities in both the adult and juvenile systems, and yet we seem to make so little progress, or no progress, and it is clearly a very intractable problem. I think people of goodwill are very concerned about it, and so it is frustrating that we don't seem to make progress.
It's interesting that you're seeing a little bit of a trend happening and some changes being made in this particular area. Are there other things that have changed since the 90s, since the 80s, when we were so punitive with children? Any other recognitions, any other steps forward that you think the system has made that you would like to see continue?
Well, we've had a series of decisions from the United States Supreme Court. Between 2005 and 2016, the court issued 5 decisions in which it embraced the science. And essentially, it relied fully upon the scientific research that was initially coming out of the MacArthur Research Network on Adolescent Development and Juvenile Justice that Elizabeth was a part of. And that those decisions, which ended up prohibiting the most severe sentences for kids who were being tried in the adult system. We eliminated the juvenile death penalty. We eliminated life without parole sentences for children convicted of non-homicide crimes. We eliminated mandatory life without parole sentences for kids convicted of homicide crimes. And we also changed the way in which we approach custodial interrogation and the requirements for the imposition of Miranda warnings as well for children, adopted a different standard for kids as compared to adults. The importance of those decisions is that, of course, it's coming from the highest court in the land. The court is declaring that this is the boundary of where we do and don't apply the Eighth Amendment or the prescriptions of the Eighth Amendment. That framework, that developmental framework that the court adopted in thinking about constitutional interpretation necessarily filtered down to state Supreme Courts, to state trial courts, to lower federal courts. So that is a profound development over the course of the last 15 years that I think can't be underestimated in terms of thinking about today.
And the symbolic value and importance of the Supreme Court's holdings are, as Marsha suggests, really can't be overstated. And I think it sort of captures the importance of these holdings, that the court explicitly announced children are different. And when you think of that in comparison to adult time for adult crime, not so long before, as the mantra of the punitive law reforms, it suggests, how that these opinions just signaled that the court was not embracing that punitive approach. And as Marsha suggested, these opinions, in fact, the sentencing opinions particularly, affected a very small number of offenders who were sentenced as adults for very serious crimes. But they have been cited and pointed to in a broad range of reforms, including courts holding that juveniles cannot be placed in sex offense registries, and citing these sentencing opinions that had nothing to do with sex offenses, or that a delinquency adjudication can't be used as a predicate sentence under a 3 strikes law, where you have, on your 3rd offense, you're sentenced to life in prison. And that wasn't the subject of the court's opinions, but the ripple effect of these opinions and of the courts embracing this developmental framework have been quite remarkable, I think.
And we've seen it in legislative bodies as well. So I'm going to mention again recent legislation signed by Governor Brown in California, which also changed their transfer laws. And essentially, in California now, 14 and 15-year-olds who up until the end of September were eligible to be prosecuted as adults can no longer be brought into the adult criminal justice system. That's very groundbreaking, and that may well be the highest boundary, the oldest age boundary we've seen, absolutely prohibiting prosecution as an adult. That decision that came out of the state legislature in California that was signed by Governor Brown is fully rooted in the developmental research, but the developmental research is accepted because the U.S. Supreme Court accepted it. And so you have had this remarkable ripple effect, as Elizabeth said, where once the court said we get it, once the court said this is true, everyone who is a policymaker, a stakeholder, a participant in that system begins to think differently about how that system should operate.
And it's sort of interesting to note that California greatly expanded its transfer law in the 90s and early 2000s to include many, many different offenses as transfer eligible for 14 and 15-year-olds. And this recent legislation is a remarkable reform of that statute.
Clearly, California has done some really innovative things to help protect kids when they enter the justice system. Have you noticed anything else in your research or in your practice?
Well, I think that I'm going to give California a couple more shout outs, just because I think in the last 8 years, certainly under Governor Brown, there have been remarkable advances that advocates have achieved on behalf of kids. They also have led the way in some respects in responding to the Supreme Court's ban on life without parole for kids in the adult criminal justice system by providing fairly generous opportunities for review of decades-long sentences before those sentences are actually served. And again, I think in some respects, legislatively, they are leading the way on a lot of these issues. At the same time, we are seeing significant progress at the state Supreme Court level. For example, the Pennsylvania Supreme Court struck juvenile sex offender registration, as Elizabeth was mentioning, and relying almost very much so on the developmental research and this principle that kids are different and that it was okay to treat kids differently who may indeed be convicted of sex offenses than we treat adults. The other state Supreme Courts have adopted very favorable views of how long is too long in terms of resentencing some of these individuals who have been sentenced to life without parole. Recognitions that we could have virtual life sentences, not simply formal life without parole sentences.
The Iowa Supreme Court has prohibited any mandatory minimum sentence for a juvenile, again, pointing to the Supreme Court opinions, which were very consistent with the Iowa court's holding in spirit, but which had nothing to do with that kind of law.
Yeah, I'd give a shout out here as well to Washington State, which in the same vein prohibited the application of any mandatory sentencing statutes that adults will be subject to every day in Washington State, but can no longer be imposed on kids.
If each of you could give one piece of advice to anybody that has to interact with a child who's entering the justice system, what would it be?
My advice would be that paying attention to the developmental realities of adolescence and the effect of immaturity on criminal offending is not, as a basis of policy, is not only good for young offenders, but it's good for society. And that framework of realizing, one, that adolescents are changing, that criminal behavior is a product of immature brain development, and that most adolescents will grow up and mature out of their sort of impulsive and tendencies to do things that they might never do as adults, that basis for policy can be justified just on a social welfare grounds, that that's good for all of us, that it's less costly, and that it is more effective in promoting the goal of crime reduction.
I would say I would encourage them to listen to the voices of children and to listen to the voices of their families. They are the consumers of the justice system, and we often forget that those who are most directly affected and impacted by a system may have the most to teach us about the ways in which the system functions well and the ways in which it doesn't. And I think hearing those voices can also help policymakers, decision makers recognize that the notion of second chances matters. Being able to develop and implement policies that allow these kids to come back home, to stay home in the first instance, to stay connected to their communities, their schools, their homes, is a much better bet on future crime reduction than the punitive responses that we have often favored.
And I just note that the Juvenile Law Center has been a leader in bringing the youths themselves to the table to have a voice in policy and in how we think about the response to juvenile crime.
Well, thank you both, and thank you for the work that you do.
Thank you.
Thank you.
You've reached the end of another episode of Reasonably Speaking. Thank you for listening. Visit ali.org to learn more about this important topic and our speakers. Reasonably Speaking is produced by the American Law Institute with audio engineering by Kathleen Morton and digital editing by Kristen Evans. Podcast episodes are moderated by Jennifer Marinigo, and I'm Sean Kellum.